Go ahead.
I don't know. Okay, the permanency hearing report shall include, but need not be limited to, up-to-date and accurate information regarding, one, the child's current permanency goal, which may be I, return to the parent or parents. Double I, placement for adoption with the local social services official filing a petition for termination of parental rights. 3, referral for legal guardianship. 4, permanent placement with a fit or and willing relative. Or 5, placement in another planned permanent living arrangement that includes a significant connection to an adult who is willing to be a permanency resource for the child if the child is age 16 or older, including documentation of, and then there's this whole long list, intensive, ongoing, and as of the date of the hearing, unsuccessful efforts to return the child home or secure a placement for the child with a fit and willing relative, including adult sibling, legal guardian, or an adoptive parent, including through efforts that utilize search technology, including social media, to find biological family members for children. B, the steps being taken to ensure that. And then there's an I, the child's foster family home or child care facility is following the reasonable and prudent parent standard in accordance with the guidance provided by the United States Department of Health and Human Services. And 2, child has regular ongoing opportunities to engage in age or developmental appropriate activities, including by consulting with the child in an age appropriate manner about the opportunities of the child to participate in activities. And C, the compelling reasons for determining that it continues to not be in the best interest of the child to be returned home, placed for adoption, placed with a legal guardian, or placed with a fit and willing relative. 2, the health, well-being, and status of the child since the last hearing, including a description of the child's health and well-being, information regarding the child's current placement, an update on the educational and other progress the child has made since the last hearing, including a description of the steps that have been taken by the local social services district to enable prompt delivery of appropriate education to the child, including but not limited to, do you want me to read this too?
Yeah, keep going.
Okay. Where the child is subject to Article 65 of the Educational Law or elects to participate in an educational program leading to a high school diploma, the steps that the local social service district or agency has taken to promptly enable the child to be enrolled or to continue enrollment in an appropriate school or educational program leading to a high school diploma. B, where the child is eligible to be enrolled in a pre-K program pursuant to Section 3602E of the Education Law, the steps that the local social service district or agency has taken to promptly enable the child to be enrolled in an appropriate pre-K program if available. C, where the child is under 3 years of age and is involved in an indicated case of child abuse or neglect. Oh, I know what that is. Or where the local social services district suspects that the child may have a disability as defined in Subdivision 5 of Section 2541 of the Public Health Law, or if the child has been found eligible to receive early intervention or special education services prior to or during the foster care placement in accordance with Title 2A of Article 25 of the Public Health Law or Article 89 of the Education Law, the steps that the local social service district or agency has taken to make any necessary referrals of the child for early intervention, preschool special education, or special education evaluations or services as appropriate, and any available information regarding any evaluations and services which are being provided or are scheduled to be provided in accordance with applicable law. And D, where the child is at least 16 and not subject to Article 65 of the Education Law and elects not to participate in an education program leading to a high school diploma, the steps that the local social services district has taken to assist the child to become gainfully employed or enrolled in a vocational program. 4, a description of the visitation plan or plans describing the persons with whom the child visits, including any siblings, and the frequency, duration, and quality of the visits. 5, where a child has attained the age of 14, a description of the services and assistance that are being provided to enable the child to learn independent living skills, and a description other service being provided to the child, the status of the parent, including the services that have been offered to the parent to enable the child to safely return home. This is ridiculous.
I know.
The steps the parent has taken to use the services, any barriers encountered to the delivery of such services, the progress the parent has made towards reunification, and a description of any other steps the parent has taken to comply with and achieve the permanency plan if applicable. This is like a fucking run-on sentence for 20 pages.
Wait, do you hear the thing I'm going to read?
Oh my god, 4. Now there's like numbers, I don't even know where they're coming from. 4. A description of the reasonable efforts to achieve the child's permanency plan that have been taken by the local social service district or agency since the last hearing. The description shall include I. Unless the child is freed for adoption or there has been a determination by a court that such efforts are not required pursuant to Section 1039B of this Act, the reasonable efforts that have been made by the local social services district or agency to eliminate the need for placement of the child and to enable the child to safely return home, including a description of any services that have been provided. How is there more to this? Double I, where the permanency plan is adoption regarding to placement with a fit and willing relative or another planned permanent living arrangement other than return to parent, the reasonable efforts that have been made by the local social services district or agency to make and finalize such alternate permanent placement, including a description of any services that have been provided and a description of the consideration of appropriate in-state and out-of-state placements. 3. Where a return home of the child is not likely, the reasonable efforts that have been made by the local social services district or agency to evaluate and plan for another permanent plan for consideration, just keeps going on. For considerations of appropriate in-state and out-of-state placement and any steps taken to further a permanent plan other than return to the child, or...
We mean return to the parent, right? It says parent.
Sorry. Return to the child's parent is what I'm supposed to say. Or where a child has been freed for adoption, a description of the reasonable efforts that will be taken to facilitate the adoption of the child and the recommended permanency plan, including, a recommendation regarding whether the child's current permanency plan a recommendation regarding whether the child's current permanency goal should be continued or modified, the reasons therefore, and the anticipated date for meeting the goal. A recommendation regarding whether the child's placement should be extended and the reasons for recommendation, any proposed changes in the child's current placement, trial, discharge, or discharge that may occur before the next permanency hearing, a description of the steps that will be taken by the local social service district or agency to continue to enable prompt delivery of appropriate educational and vocational services to the child in his or her current placement and during any potential change in the child's foster placement, during any trial, discharge, and after discharge of the child in accordance with the plans for the child's placement under the next term permanency hearing. 5. Whether any modification to the visitation plan or plans is recommended and the reasons therefore. 6. Where a child has attained the age of 14 or will attain the age of 14 before the next permanency hearing, a description of the services and assistance that will be provided to enable a child to learn independent living skills.
Is that it?
No, it's still going. Obviously, they like to really talk in family court.
Yep.
7. Where a child has been placed outside the state, whether the out-of-state placement continues to be appropriate, necessary, in the best interest of the child. Where a return home of the child is not likely, the efforts that will be made to evaluate or plan for another permanent plan, including consideration of appropriate in-state and out-of-state placement. And in the case of a child who has been freed for adoption, a description of services and assistance that will be provided to the child and prospective adoptive parent to expedite the adoption of the child. Information regarding the child's eligibility for adoption. If the child is over age of 14, has voluntarily withheld his or her consent to an adoption, the facts and circumstances regarding this child's decision to withhold consent and the reasons therefore. And D, evidence, court findings, and order. The provision of subdivision A and C, section 1046 of this Act shall apply to all proceedings under this article. The permanency hearing shall include an age-appropriate consultation with the child, provided, however, that if the child is age 16 or older and the requested permanency plan for the child is placement in another planned permanent living arrangement with a significant connection to an adult willing to be permanency resource for the child, the court must ask the child about the desired permanency outcome for the child. At the conclusion of each permanency hearing, the court shall, upon the proof adduced, and in accordance with the best interest and safety of the child, including whether the child would be at risk of abuse or neglect if returned to the parent or other person legally responsible, determine the issues it's finding and enter an order of disposition in writing. 1. Directing that the placement of the child be terminated and the child returned to the parent or the person legally responsible for the child's care with such further orders as the court deems appropriate, or where the child is not returned to the parent or the person legally responsible, whether the permanency goal for the child should be approved or modified, and the anticipated date for achieving the goal. The permanency goal may be determined to be return to the parent, placement for adoption with the local social services official, filing a petition for termination of parental rights, referral for legal guardianship, permanent placement with a fit and willing relative, or this is fucking never ending, placement in another planned permanent living arrangement that includes a significant connection to an adult willing to be a permanency resource for the child if the child is age 16 or older and the court has determined that as of the date of the permanency hearing, another planned permanent living arrangement with a significant connection to an adult willing to be a permanency resource for the child is the best permanency plan for the child, and there are compelling reasons for determining that it continues to not be in the best interest of the child to return home, be referred for termination of parental rights and placed for adoption, placed with a fit and willing relative, or placed with a legal guardian.
Oh wait, so what are they I think that whole run-on sentence, the only thing that was important that I got from it is something about when they're going to refer them for termination of parental rights. Was that even,
okay.
Did you even say that, or was I imagining it?
No, I did say that, but this fucking sentence is like literally like 20 lines long.
Oh.
Okay, oh yeah, let me see. Okay. Willing to be, living arrangements with a significant connection to an adult willing to be a permanency resource for the child is the best permanency plan for the child, and there are compelling reasons for determining that it continues to not be in the best interest of the child to return home, be referred for termination of parental rights, and placed for adoption, placed with a fit and willing relative, or placed with a legal guardian.
Okay, so this is the part where they're finally getting to the point where we're going to go to Article 6.
Yes.
Okay. Because my thing that I'm going to read to you right now, when you're done with that, unless you want to break and I'll start and then we can go back to it.
Oh my god, I'll finish, but...
Yeah. Okay, so...
Holy shit, this is really long.
But the thing I'm going to read is after that.
Okay, so you want me to continue?
Yeah.
Okay. So by placing the child in the custody of a fit and willing relative or suitable person, or continuing the placement of the child until the completion of the next permanency hearing, provided, however, that no placement may be continued under this section beyond the child's 18th birthday without his or her consent, and in no event past the child's 21st birthday, provided, however, that a former foster youth who has previously discharged from foster care due to a failure to consent to continuation of placement may be returned to the custody of the local commissioner of social services or other officer, board, or department authorized to receive children as public charges if the court has granted the motion of the former foster care youth or local social services official upon a finding that the youth has no reasonable alternative to foster care and has consented to enrollment in and attendance at a vocational or educational program in accordance with Section 1091 of this Act. 3. Determining whether reasonable efforts have been made to effectuate the child's permanency plan as follows. Unless the child is freed for adoption or there has been a determination by a court that such efforts are not required pursuant to Section 1039B of this Act, whether reasonable efforts have been made to eliminate the need for placement of the child and to enable the child to safely return home. B, where the permanency plan is adoption, guardianship, placement with a fit and willing relative, or another planned permanent living arrangement other than return to the parent, whether reasonable efforts have been made to make and finalize such alternate permanent placement, including consideration of appropriate in-state and out-of-state placement. 4. Where return home of the child is not likely, what efforts should be made to evaluate or plan for another permanent plan, including considerations of appropriate in-state and out-of-state placement. 5. The steps that must be taken by the local social services official or agency to implement the educational and vocational program components of the permanency hearing report submitted pursuant to subdivision C of this section and any modifications that should be made to such plan. Specifying the date certain for the next scheduled permanency hearing. Where placement of the child is extended, such order shall also include, this is where they have extensions, a description of the visitation plan or plans. Where the child is not free for adoption, a direction that the child's parent or parents, including any non-respondent parent or other person legally responsible for the child's care, shall be notified of the plan in conference, or conferences to be held pursuant to subdivision 3 of section 409 of the Social Services Law, and notification of their right to attend such conference or conferences and their right to have counsel or another representative with them. C. Where the child is not free for adoption, or a direction that the parent or other person, the PLR, for the child's care, keep the local social services district or agency apprised of his or her current whereabouts and a current mailing address. D. Where the child is not free for adoption, and notice that if the child remains in foster care for 15 of the most recent 22 months, the local social services district or agency may be required by law to file a petition to terminate parental rights. E. Where a child has been free for adoption and is over age 14 and has voluntarily withheld his or her consent. It's like so repetitive.
I know. I think we got the point. What is the last sentence of it say?
Oh my God, there's so much. Okay. Recommendation that to investigate the facts and circumstances concerning the discharge of responsibilities for the care and welfare of the child, recommending that the attorney for the child, local social services district or agency file a petition, whatever. This is a start, right? So I think this is new. Hold on. New bill September and cannot be put together? What the fuck does that mean? That's
I
what
don't
it says.
know. Take a picture of that and I'll ask Dan tomorrow what that means.
Shit, I can't even take a picture because my phone sucks. I'm gonna try. I can't.
Oh.
I know. That's why I'm sending you snapshots. No, I can't.
Okay.
I have no home button, so I just have to I have my home button on my screen. It doesn't really work. But I'll send you the I'll just text you what it says because I've never seen it before.
Okay.
All right, hold on. I'm trying to go to the end. It just goes on and on and on and on. There's shit that's effective until January 21st, 2018.
Oh, so they passed a new thing in January?
Yeah. Yeah, this is new.
Wow.
This is some new shit that's from January 2013. It's epic. The court may make an order directing local social services district or agency to undertake diligent efforts to encourage and strengthen the parental relationship when it finds such efforts will not be detrimental to the best interests of the child and there has been no prior court findings that such efforts are not required. Such efforts shall include encouraging and facilitating visitation with the child by the parent or other person legally responsible for the child's care. Such order may include a specific plan of action for the local social services district or agency, including but not limited to requiring that such agency assist the parent or PLR in obtaining adequate housing, employment, counseling, medical care, or psychiatric treatment. Such order shall also include encouraging and facilitating visitation with the child by the non-custodial parent and grandparents who have the right to visitation pursuant to whatever section. Such order may also include encouraging and facilitating regular visitation and communication with the child by the child's siblings and may incorporate an order, if any, is issued pursuant to this section or section 1027A or 1081 of this whatever and the domestic relations law. For purposes of this section, siblings shall include half siblings and those who would be deemed siblings of half siblings, but for the surrender, termination of parental rights, or death of a parent, Nothing in this subdivision shall be deemed to limit the authority of the court to make an order pursuant to section 255 of this act.
Okay, so now let me do this one. Because
Oh my God,
first I'm
yeah.
going to sum up what I think you just read.
I don't even know what I read.
I'm going to try to sum up what I think you might have just read. So the first thing was that no later than 14 days before the date certain for a permanency hearing scheduled, the Social Services District shall serve notice of permanency hearing and the report by regular mail upon the child's parent, unless the rights have been terminated, the PLR at the most recent address known, the foster parent where the child currently resides, each of whom shall be a party, the agency supervising the care of the child on behalf of the Social Services District, the child's attorney, and the respondent parent's attorney. And I said the child's attorney. And if the child is 10 years of age or older, by regular mail on the child. Then it goes on to say that the notice of the hearing only, so just the notice of the hearing, shall be provided to a former foster parent the child resided for a continuous period of 12 months, and then the pre-adoptive parent, relative, or former foster parent. Okay? Then, what I'm going to read you right now, this is in Article 6, and this is originating proceeding for the commitment and guardianship of a child. Okay, so this is the contents of petition. And the petition has got to have 5 things in it. 1, child is under 18. 2, child is in the care of an authorized agency. 3, the authorized agency has made diligent